recording before I did that. So, welcome. Thank you for joining us this evening. Deborah, would you be able to talk a bit about the Detroit chapter of the League?
Absolutely. Thank you and welcome. And I'm so excited about this program that I'm not going to take up a lot of time, but I hope you all know about the League of Women Voters. The League of Women Voters is, of course, a nonpartisan political organization with local, state, and federal ties, local components. For nearly a century, we have worked to empower voters by informing citizens about the local candidates, public policy, and advocacy programs. Uh, Most importantly, that everyone is registered and know that they have the right to vote. Democracy is not a spectator sport. And this, I'm going to move out of the way and welcome our speakers and thank you for joining us. And please think about joining the league.
Thank you, Deborah. Um, Tonight, our speakers are Dr. Orville Vernon Burton, Judge Matthew J. Perry Professor at Clemson University. I'm sorry, of History at Clemson University, and Armand Derfner, Esquire, a longtime civil rights lawyer. They partnered on Justice Deferred, Race in the Supreme Court, which was published in 2021 by the Harvard University Press. We have copies in the DPL system, and we'd be happy to help you find it. As a recognized authority on race relations, Dr. Burton is often called upon as an expert witness in discrimination and voting rights cases throughout the United States. A graduate of Princeton University and Yale Law School, Armand Derfner has been practicing constitutional and civil rights law for 60 years in Charleston, Mississippi, Washington, D.C., and elsewhere. He has specialized in protecting the right to vote and especially helping to shape the Voting Rights Act. Tonight, they are going to be talking about a bit of history on voting rights and then uh, a bit about the current situation, which I think we are all aware of right now. So, if you are ready to start,
Sure. Can you hear me okay?
you're a little garbled.
Oh, can you hear me all right, man?
Yes, now we can hear you fine.
Okay. All right. Well, thank you so much, and we appreciate you lowering expectations. I want to sort of begin with the late Congressman John Lewis, with whom Armand was very close friends and worked with, particularly on the renewal of the voting right in 1982, that we'll be talking about. But John Lewis asked us to be activists, and even though we're sitting here, we can still be activists, learning new concepts and ideas. I truly believe history empowers us and calls us to action. Whether you believe history repeats, echoes, rhymes, we have to study to understand how we got here, and then we might learn lessons as to when to cause good trouble or necessary trouble. Particularly in these trying times, facts and evidence, which is history, must remain important to universities and to the courts. Humanities in history deals with the tough questions, and that's what we want to look at briefly today. I'm going to try to do. Armin wanted in particular to do some background, and so we'll go very quickly because the going on now is the most important things to be talking about. Now, Abraham Lincoln believed that if he would be remembered for anything, and the greatest thing that he did was, in fact, the Emancipation Proclamation. But we believe instead that it's Lincoln's understanding of liberty and what he did with the 13th, 14th, and 15th Amendment. Yes, I know he was dead by the time they're all ratified, but very much responsible for the 13th. And it was in sort of his name that they called on for the ratification of the rest of them. But we believe that is his greatest legacy. In 1864, near the end of the Civil War, Lincoln spoke to a group in Baltimore about differing notions of freedom. The world has never had a good definition of the word liberty, and the American people just now are much in want of one. As was his custom, he told a simple story. The shepherd drives a wolf from the sheep's throat, for which the sheep thanks the shepherd as a liberator, while the wolf denounced him for the same act as the destroyer of liberty, explicitly making clear to whom this new definition of liberty applied. He explained, especially as the sheep was a black one, plainly the sheep and the wolf are not agreed upon a definition of the word liberty. I'm thankful that the wolf's definition had been repudiated, but actually the repudiation is a never-ending story and is being argued over today in our country and in our current Supreme Court. Lincoln professed that freedom meant aiming for equality. In his Gettysburg Address in 1863, midway through the war, he promised a new birth to freedom for a nation conceived in liberty and dedicated to the proposition that all men are created equal. Now, the words all men are created equal were only in the Declaration of Independence. If freedom were to have a new birth, the U.S. Constitution would need new amendments. And I like to argue that Lincoln actually took our mission statement, the Declaration of Independence, and put it into the Constitution. The rule of law meant a redefinition of the role of national government as protector of freedom and liberty. Prior to the Civil War, we the people wanted limited government power, freedom from government. Remember, it was freedom from a king and a king's dynasty. The Bill of Rights protected the people from government powers. Amendment 1 begins, Congress shall make no law respecting. The First Amendment therefore creates an understanding that the government by non-action protects freedom. The Civil War Reconstruction Amendments, the 13th, 14th, 15th, revolutionized freedom in the United States, assuring that it was protected by law. Each of the three Reconstruction Amendments, the 13th, which outlawed slavery, the 14th, which granted equal citizenship to people born in the United States and ensured due process, and the 15th granted the right to freedom to all male citizens. Every one specifies that Congress shall have the power to enforce. With these amendments, the Constitution was fundamentally altered. The extent of a citizen's social, civil, and political rights, and whether those rights were separate or unitary, remained open to debate, but the Constitution now committed the power of the federal government to the equal extension of those rights. I'm not going to spend much time. Let's quickly look at the amendments, and we won't go. Let's see, is that not moving? Maybe we won't do any time. All right. There we go. I want to argue that the 13th Amendment, you'll see the first time you have Congress shall have the power to enforce the article by appropriate action. And the first few cases that came out in the federal judiciary argued that this amendment also did away with the badges of slavery. And hopefully we can have time to talk a little bit about what that has meant over the years. And just the Southern reaction, how you got through Reconstruction. Why we spent so much time on Reconstruction is because there's been this mythology created. Reconstruction was not this tragic era, except that it ended. And it's also a myth that it all ended in 1876 when the troops were withdrawn from the former Confederacy. In fact, the troops were never withdrawn, they just quit protecting the Republican legislatures. The tragedy is that this was truly the most progressive period, I believe, particularly in what is the American South, and maybe in the nation, but certainly the American South, with the kind of laws and things that were passed, and we can spend about that now. Here's of course, Section 1 of the 14th Amendment. It first deals with birthright citizenship, something that's for the court right now, and I know that Armand wants to speak to that a little bit. But one of the reasons this is birthright citizenship, almost 100% of all African Americans in 1860 and then 1864, 65 had been born in the United States. But look at this second sentence. This is the one that I find extraordinarily important for us, and that is the second sentence that is there. And it reads, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, even today, people, let alone judges, have different views of what immunities and privileges are, or what due process or equal protection of the laws mean. The lack of clarity has meant that the Supreme Court and the court system would be involved in determining their meanings. There was a section 2 that seemed like it was dealing with voting, but we'll skip that because it's never been used. But the idea was that if people had, come on, it's not going to move. Where we go? If in fact not allowed to vote, the Congress would reduce that proportion of the representation, but it has never been used. And then, of course, the 15th Amendment. And you would not have needed the 14th or the 15th Amendment if people had sort of obeyed, of course, the 13th Amendment and took it literally as the way it was interpreted. Now, what Armand and I have argued in our book, and I think that we may be the first to really have shown all of this, is that you put together an extraordinary group of laws. Let's go back a little bit. Some 40 laws in all that were passed with the Enforcement Act, the 13th and 14th and 15th Amendment, the Ku Klux Act of 1871. But we counted up some 40 laws. And with these laws, and with particularly the federal government, and this is, of course, one of my favorite, is just a picture with Congressman Robert Brown Elliott and sort of the crowning achievement in 1875, the Civil Rights Act. That there was a wall of protection. Black people could, in fact, vote. They could elect candidates of their choice. So one way to protect them, and then they had the federal government and the Constitution and these something 40 laws, sort of a brick wall. So what we then show is that Reconstruction does not end all at one time, but it is bit by bit. And the Supreme Court is playing the major role of taking away the rights of black people. And it's not that people at the time did not think that was the end of Reconstruction. People were waiting for the next election. And I won't go through each of them. We can come back to this if we have time because I think it's important. Is that okay with you, Armand? I think it's important that we literally get to where we are today because I think we are in a similar crisis in some ways as we were in the Reconstruction period and what comes afterwards, often called the sort of undoing of Reconstruction, which we sort of end in 1898. One of the things we wanted to point out is the Colfax riot. I think this is a great example of one, though. And the Colfax riot is the Cruikshank case. Two incredible court cases came down, in fact, the very same day. And the Cruikshank case dealt with the Colfax massacre, where over 100 black people were massacred and killed, and they had been convicted in the lower court, but that was appealed. It went to the Supreme Court, and this was like waving a red flag in front of a bull. The court said that if the people who were killing African Americans or Republicans or others at that time were not part of the state. That is, if they were not the state militia, if they were not sheriffs, then they couldn't be convicted in federal court. And of course, with the jury cases and all white juries, there was no hope. The people who heard this, the ones I know about best, are in South Carolina, but Louisiana and Florida the same, knew that they could get away with murder. And you had incredible, what they like to call riots, but they were not riots, they were massacres of people. In South Carolina, it goes on and on and on. And I think that's just one of these cases that undermines. You can see them. I threw in Santa Clara County versus Pacific Railroad for one reason, and that is simply that that is the case that made corporations persons, according to the 14th Amendment. And with that, today, almost all cases under the 14th Amendment, over 85%, are about corporations. And it interests me so much because the person who kept this law, got it under control, was of all people the Tillman Act, Pitchfork Ben Tillman, who was involved in these massacres of 1876 when the Colfax and case came down, Cruikshank. Uh, and yet, Citizens United, that opened this back up to this huge era of extraordinary wealth division in the United States and can bring in dark money, overturned the Tillman Act. It's just one of these great ironies for me. Why Williams versus Mississippi and Plessy v. Ferguson is sort of where we end Reconstruction is because, particularly with Williams v. Mississippi, it says that these constitutions are legal as long as they don't say we're trying to disfranchise black people in the text. They can use all sorts of disfranchising neutral language and not get to them and use them. I'm going to quickly jump. You can ignore Woodrow Wilson, but to Charles Evan Hughes, who became certainly one of my heroes. Wilson had been because he was a historian and I'd gone to Princeton. But Charles Evan Houston ran against the president. He is the person that Armand and I decided really deserves the credit that set up what we think of as the Warren Court. And what I love about him as a historian, he's the first person that says, let us see the evidence. And with the evidence, it began the turnaround of the court. There's a lot of other cases in our book. We actually have a picture of him with a list of some of those important cases and what those cases said and did, such as you could not by indirection do the kind of thing you couldn't do by the law. But extraordinary, the Alonzo Bailey case, the grandfather clause in Oklahoma, one case after another. So with that, I think I will stop, Armand, and let you correct all my mistakes I have made. So I skipped everything to get there. We had way more than this, and we can go back to talk about any of this you want to. And as Armand and I always like, feel free to disagree with us. It's all right. You won't hurt our feelings.
Okay. I think that the discussion about Reconstruction is a good jumping off place for talking about today's court as well. In the Federalist Papers, Alexander Hamilton wrote that the judicial branch is the least dangerous branch, has no soldiers, no power of the purse, etc. At that time, it may have been true, in part because it was not clear, in fact, it had not been done, that the Supreme Court or the courts could override what the legislature had done, what the legislature and the president had done. So, for example, in Marbury versus Madison, that we all learned about in grade school or high school, the Supreme Court said it had the power to say that a law passed by Congress and signed by the president was not valid because it was not in accordance with the Constitution. Well, that set off a trend that has now led to the Supreme Court, by today's standards. Many people think it is the most powerful branch, not the least powerful. And one of the problems I think a lot of us see today is a little bit like what the problem was in the Reconstruction. That is, the Supreme Court's job, the Supreme Court's main job is to preserve our democracy. And part of that democracy involves maintaining the balance of power among the different branches of government. We have the beauty, most of us think that the beauty of our nation and our democracy and our republic is the balance of different forces. So, for example, just in the federal government, we have the executive branch, the legislative, and the judicial. And then we also have the tension between the federal government and all the different states. So what happened in Reconstruction was that what we call the Reconstruction Amendments that Vernon has talked about, the 13th, 14th, and 15th Amendment, they really put the federal government into a position of some significance, whereas before that, before the Civil War, the federal government had really been thought of as the secondary government, with the states being in charge. Well, what happened in Reconstruction was that the federal Congress and the president, acting with the power of the federal government, passed laws and tried to run the country in a way in accordance with the new amendments and with the Constitution. And the southern states, not really, the southern states who were still basically there was a tug of war between new people in charge and the former people. In the Supreme Court stepped in and said, no, we are not going to let the federal government pass its laws. The Supreme Court struck down repeated laws that Congress had passed and the president, and mostly General Grant, had signed. And so the Supreme Court really contributed to the end of Reconstruction and the restoration, the creation of Jim Crow, by stepping in and deciding for itself what the balance of power was going to be, and basically putting the federal government out of business and letting the recalcitrant states return to the government that they had known, which the Civil War was supposed to undo. Well, today what we have is, in my mind, a Supreme Court, whether you agree or disagree with the president, the Supreme Court is exercising its power, in my view, to alter the balance of power among the different branches. So the Supreme Court is enhancing presidential power, is sweeping away various restraints on the presidential power, ignoring what the legislature is supposed to do. And in that way, both altering and undermining, in my view, the constitutional scheme. Again, as I say, it doesn't much matter whether you agree with what the president is doing or whether you don't agree. But the Supreme Court has, in many ways, been undermining that balance of power. And I think in that way, it is really undermining our democratic scheme. So let me just give you a couple of examples, okay? And one of the big cases, we will find out soon if there are limits, because the tariff case, everybody's been expecting the tariff case to be handed down any day, a week ago, a month ago, etc. The tariff case is simply the president has imposed a group of tariffs, as well as talking about how that he's going to impose extra tariffs or he's not going to impose them. Tariffs are laws. They're laws like other laws. And so presumably, tariffs are laws like Congress, like the laws that Congress is supposed to pass. But the president says he can do it by himself. And we will find out if the Supreme Court is going to bow to that. There's a question about presidential immunity. You all were not, most of you are probably not as old as I am, or maybe Vernon, but I remember when Richard Nixon was president. And when Richard Nixon was president, he had these he had these tapes that he had been recording in the White House, and and it was discovered that he had these tapes. The tapes were requested by the special prosecutors, and President Nixon said he wasn't going to give up the tapes, and that case went to the U.S. Supreme Court. The Supreme Court decided that he had to hand the tapes over. The president's lawyer at that time, people were wondering, will President Nixon comply with that order? And the president's lawyer at that time said, this president does not disobey the Constitution. And so President Nixon gave up the tapes, and that ended his presidency. He probably knew when he gave up the tapes that it was going to end his presidency. Well, the Supreme Court now, in a case called, I think it's called U.S. against Trump or something like that, decided that the president not only cannot be prosecuted for anything that is arguably within the scope of presidential duties, but nothing related to the scope of presidential duties can even be looked at as evidence. What that means is that if it turned out that the president was making tapes and speaking into those tapes about doing criminal acts, nobody could ask for those tapes, and the Supreme Court would say he doesn't have to give them up. If President Richard Nixon in 1974 had this Supreme Court, he wouldn't have given up the tapes. He'd still be president. So that's one place where the Supreme Court has really turned the law and the Constitution radically around. There are others. We've had independent agencies. You all remember learning in high school that in 1887, Congress enacted a law, and the president signed it. I think it was President Grover Cleveland, creating the Interstate Commerce Commission. That was the first independent agency. And since that time, we've created a number of independent agencies which are created by Congress, subject to Congress's laws, administered by appointees of the president, with typically independence on the part of those agents, because we know that you can't have a fair government if people aren't independent when they do some things. They have to be accountable to somebody. With Congress members, it's accountable to the people or accountable to other members of Congress. The president's accountable to the people, no longer accountable to the criminal process we just learned. But the independent agents are accountable to Congress and accountable to everybody else. But they at least have independence. And the Supreme Court has, in a number of cases, in this Supreme Court, has indicated that it is going to overturn a 100-year-old precedent called Humphrey's Executor, in which the Supreme Court of, I think, 1935 had said, if an agency head is appointed for a specific term, let's say 3 years or 5 years, which is typical, you can't just say, well, that term is over. The president, decided that 3 years or 5 years, the heck with that. I've decided I'm going to fire you today. That's what the Supreme Court said a president could not do in 1935. At that time, it was a very powerful president who wanted to remove Mr. Humphrey. It was FDR. And the Supreme Court at that point said, no, you cannot do it because the law created terms for these officers, and you can't just ignore them just because you're the president. Well, it looks like the Supreme Court of today is going to overturn that. So my concern, and we can get into specific areas because I know we're supposed to be talking about some things, including especially the right to vote and especially the right of minority people to vote. But the basic problem we have, I think, to start with, is that the Supreme Court is not in the business of maintaining our balance of power that has kept our democracy going for so long. Vernon, got some comments at this point?
Yeah, I agree. A lot of people are arguing that basically what we have now are um politicians in black robes on the Supreme Court. I won't go that far, but it's looking bad. And I do think as we deal with the First Amendment, because as Armand has said over and over again, we just ask for consistency from folks who have always ruled for the First and Second Amendment as broadly as it could be, and the 13th, 14th, and 15th as narrowly as they could be. So we'll see where they really stand, I think, now that the First Amendment is being used to go after or have rights against what this current administration, who so many of them seem to be beholden to and are in line with, says. So I think that will be a very telling moment, Armand. I was going to spend some time, and I did not because I did that amicus brief was the first name on it on the Colorado case that became the case that Justice Roberts took from Justice Scalia to say that the president is above the law, something that's totally unprecedented, totally no evidence for. Uh, that to me was one of the worst decisions that we will see for some time to come. I hope I'm wrong, but
I think that going back to the issue of how the Supreme Court's dealing with cases, one good example is gerrymandering. Excuse me.
get this
For many years, the Supreme Court um, flirted with the question of whether partisan gerrymandering is okay or it's justiciable, meaning can you sue about it? And you remember in 1962, the Supreme Court, for the first time in Baker versus Carr, said that a voter could go to court and challenge malapportionment in the state legislature or city council. In other words, where some districts were bigger than others, and some citizens therefore had a more powerful right to vote. Well, the question was, if you have population equality, that doesn't necessarily give you fairness. And so the question is, what happens if you have a legislature that comes up with a partisan gerrymander? In other words, let's say that the state is half Democratic and half Republican. North Carolina is a good example. They've been like that for years and years. But if if one side gets into the legislature, they can draw districts that make even a half and half state turn out to have 65, 70% representatives of one party rather than the other. Well, the Supreme Court flirted with that question for many years and just never quite decided it. And then about 7 years ago, in 2019, the Supreme Court finally said, well, partisan gerrymandering is not something we can deal with. We don't have any standards, so the federal courts cannot throw out a reapportionment on the theory that it's gerrymandering. In that same case, which was called Rucho against Common Cause, a case from North Carolina, the Supreme Court said, however, partisan gerrymandering is evil, it's undemocratic, it's unfair, it cannot be condoned. Those are the words they used, very strong language. But they said at the same time, we don't have standards for deciding when is too much. So they sort of grudgingly said, we're going to have to live with it, but we don't like it. Okay, well, that has somehow changed. That has somehow changed. And now the Supreme Court, in case after case, in just the last half dozen years, has upheld partisan gerrymandering and said where judges have found that there was racial gerrymandering, which the Supreme Court had always said was off limits. That's the one place where the Supreme Court used to say partisan gerrymandering, if it's not racially motivated, is okay. But when you get to racial gerrymandering, that's out. That's not any good. That we will throw that out. That is unconstitutional and evil. Well, now in case after case, lower courts have found that there was racial gerrymandering, and the Supreme Court has gone out of its way to overturn those rulings, even this is hard for me to say. I'm a lawyer. I've been a lawyer for many years. I've practiced in front of the Supreme Court. I've spent decades with respect to the Supreme Court. The Supreme Court now is writing opinions that are simply not true. Not true. And we'll talk about two cases for a second. On one of them, Vernon, I think, has a slide. The case
Yeah,
throughout the voting
trying to
rights
get it
act.
up. I'm gonna need some help, Armand.
Well, okay. Well, we may be able to present in the case, a case called Shelby County back in 2013, where the Supreme Court threw out the Voting Rights Act. They did it largely by taking a quote from an earlier case and just butchering it. The case from the quote from the earlier case said, "There is no doctrine called equality of the states." The Supreme Court, in a case called Northwest Austin, said there is a doctrine called equality of the states, and they took the quote from the earlier case, and we may be able to put the slide up that shows the two quotes. They took 21 words out of the middle of the quote, so the quote that said green in 1966 was turned into one that said blue in 2009. That was simply just a lie about a quote. And that was what that doctrine was based on. And that was the doctrine that was used to overthrow out the Voting Rights Act. 3 years ago, in a case from my own state of South Carolina, the question, again, with the new Supreme Court rule that says partisan gerrymandering is great and racial gerrymandering is no good, the lower court had unanimously ruled that what happened with the South Carolina legislature was a racial gerrymander, and that there had never been even a claim that it was partisan. The Supreme Court opinion said, oh yeah, the legislature said it was engaged in partisan gerrymandering, and they issued a report that said so. That is not true. It is a lie. There was no report in which the legislature ever said they were engaged in partisan gerrymandering. The Supreme Court pointed to a specific document. The document is 3 pages long. You can read it from morning to night. You will not find that it says what the Supreme Court says it said. So today's Supreme Court, and I'm really embarrassed to say this, they don't tell you the truth. You know, frankly, I learned in law school. We learn in law school theoretically. What is a court opinion? Well, a court opinion is the explanation of why the judge decided the case the way they did. Well, what you learn after a while is that a court opinion is what the judge wants you to believe is the reason they decided the case. But I never was used to the notion that Supreme Court justices of the United States actually told me lies in their opinion, and that's what they are doing nowadays. I'll stop now for the moment. Sorry to get carried away.
I just sent to Jennifer and some others the slide because it's not allowing me to share again. So maybe they can put the slide up to show what you're talking about, or just by email. Jennifer and the group that was on the link before may know how to share.
And let me just add, since I said I would stop, let me just add what the Supreme Court does also guides the U.S., guides our population, guides our people in a lot of the ways we think. They are we think of them as a moral leader, which is why Plessy versus Ferguson, when the Supreme Court said segregation was okay back in 1896, that was really awful. Because up until then, people had said, well, there's segregation, but it's no good. The Supreme Court said, oh, yes, segregation is just fine. Well, excuse me, now we have segregate the Supreme Court, while it said in Rucho that partisan gerrymandering is bad, and people have always been embarrassed to admit that they were engaging in partisan gerrymandering. State legislatures won't tell you they're doing it because it just smells bad. Now the Supreme Court has upheld it again and again, and so now people say it with pride. Donald Trump, our president, tells the Texas legislature, hey, we need 5 more Republican seats in Texas. So go out and redraw the lines to make sure we have 5 more Republican seats. And then we have California, which is theoretically a law-abiding state run by Democrats. They say, well, we don't like it. We don't have any choice. And so what we are doing is our democracy is being degraded, and we are living in a nation where our constitutional ideals, whether you agree with the ultimate policies or not, the problem is that our constitutional ideals are being degraded.
Let me read, because I think this gets at the problem, and it gets back to voting, which what this talk is supposed to be about.
Excuse me, Vernon. Ruth, you should have received the slide as well. I don't have the tools to put it up.
Okay, and I keep trying. If somebody could tell me, I had them up before and
Yeah,
don't know.
I'm sharing.
Oh, you're
I'm
sharing.
sharing it.
Yes, I see it.
I see it.
It's here now.
Yeah, if you look at what happened was the district in the Voting Rights Act case, the district that was being challenged, that was being subjected to the Voting Rights Act, said, well, you can't have the Voting Rights Act because it treats some states differently than others. And they said, we have a doctrine, and the Chief Justice of the U.S. Supreme Court wrote this opinion and said, well, there's a doctrine called equality of the states. And he pointed to the old Katzenbach case as the basis for it. And the Katzenbach case said, well, the new case, they quoted a piece of the quote, and it said, the doctrine of equality of the states doesn't prevent dealing with problems that arise later on, making it sound like there is such a doctrine and has limitations. But if you look at the whole quote on the left-hand side, the quote that the case they were quoting from said, the doctrine of equality of states does not apply. It said the only equality is that states come into the union when they're admitted on an equal basis. But there's no doctrine of equality of the states that says Congress and the president and the lawmaking has to treat the states the same. In the earlier case on the left-hand side, the Supreme Court said there is no such doctrine as equality of the states except when states come into the union. On the right-hand side, they took out the part that said there is no such doctrine. And it was based on this that in the next case, the Shelby County case, the Supreme Court said, oh, we've already decided there is a doctrine called equality of the states. Well, it's just nonsense. I mean, there is now such a doctrine because the Supreme Court said in 2013 that there is. But that was garbage, with all due respect to the members of the Supreme Court. And 2 of the most eminent judges, Richard Posner, who was appointed by Ronald Reagan, said,
very conservative,
a very conservative judge, he said, this is a doctrine of which I have never heard for the simple reason that there is no such doctrine. And then Michael McConnell, who was appointed by George W. Bush to be a federal judge, one of the leading scholars of America, said, a doctrine of the equality of states might be a good idea. I like the idea, but it's not in the Constitution that we have now. And yet, that is the doctrine, the faith doctrine, on the basis of which the Supreme Court threw out the Voting Rights Act. It saddens me. It saddens me as a member of my first case was literally 16 years ago, my first Supreme Court case. And it really saddens me to think that this Supreme Court, not just in its decisions, but in its workmanship, is falling short of what we would expect from an ordinary citizen.
Armand and I, with this, I convinced Armand to not go as badly. I kept thinking, well, this could be just, we knew that Justice Roberts had not liked the Voting Rights Act, but he was seen at that time as someone who cared about the reputation of the court. So I argued, well, maybe it was a clerk did it. Maybe they made this ellipse. But after he took that presidential immunity case, and after having sent the evidence with the amicus brief, that there's just no evidence for this and no precedent. And he takes it away from Judge Scalia and makes that ruling. I now agree when Armand was telling me it was deliberate. I don't see any other excuse for it at this time. I want to go back as a historian just to say, though, and this is important since you're the League of Women Voters. Both Armand and I have worked with the League of Women Voters. I did the South Carolina voter ID case for the South Carolina League of Women Voters. Chief Justice Marshall in 1803 in the Marbury v. Madison case that Armand referred to said, and I quote, "It is emphatically the province and duty of the judicial department to say what the law is." And then one of my, as I said, really new heroes, Chief Justice Charles Eben Hughes, expressed the reality. This is very early 20th century. We are under a constitution, but the constitution is what the judges say it is. And then at the dawn of the 21st century in 2000, Chief Justice William H. Rehnquist confirmed Congress may not legislatively supersede our decisions interpreting and applying the Constitution. So that's, I hope people realize how important it is when you go to the election to vote for the president, even though we have three branches of government, where the Supreme Court, when our legislature seems to be deadlocked in this bipartisan non-dialogue, that these judges are made lifetime appointments by the person that you elect. The people of the United States elect president. And not just the Supreme Court, but the federal justices, which may have more effect on individual lives at levels of which most voters live, as well as numerous other appointments that are in the province. So I like to say, just because you don't like that a woman wears pantsuits when you're voting, you might want to consider what it means when you're voting for someone who has the power, supposedly with the legislature's consent, supposedly, to make these lifetime decisions on who is going to be ruling on the laws and saying what the law is, that they believe that is what they've been doing since the early 19th century.
Which brings us back to life tenure. A president has a constraint. They have to get reelected, or they can't get reelected if they serve 2 terms. They didn't used to have term limits, but the people decided that was not satisfactory. And even though President FDR had been very popular, his tenure still led the people to adopt the 2-term limit. If you're in Congress, you have to run again. or you can get vetoed if you pass a bill. Uh, but the federal judiciary is up to lifetime appointments. And we know that if you have no constraint, if there's nobody who can overrule your decision, that is going to create problems. And that's why, for example, those of us who sat on Sunday evening and watched New England and Seattle, what we saw was that the referees are not necessarily the end. When Chief Justice Roberts was in testifying on his confirmation, he said, well, judges just call balls and strikes. Well, we know now that you can't just let the umpire decide the balls and strikes. The people and the leagues decided that we ought to have some electricity and some computers that will help that. We don't have that for the judges. And so we need to think about some way to limit the power of people who have all the power in the world and use it.
And what Armand and I showed in our book, and Armand really did the math on this, was just the difference in how much longer judges are on the court now than they have been in different decades and generations before. It's people are living longer, and even on your deathbed, you cannot be removed from the Supreme Court unless you make that decision.
Vernon's right. When the Constitution was drafted and they said judges have life tenure, the average judge went on the Supreme Court and stayed 10 or 15 years. Nowadays, almost every judge stays 25 years. Most of them stay more than 30 years. And so life tenure means something radically different than it did when our Constitution was drafted.
I sent the other slide too. I'm not seeing any slide if it's being shared, but if you could put up those other cases, it might be useful. The problem with a historian, maybe not so much a lawyer, is we speak in 50-minute sentences. Uh, but we want to make sure that if people have questions, they get to them. But these other cases are pretty important. Uh, of these modern cases, including where Armand and I came together, and a good example, Mobile versus Bolden, of how the world used to work, where the Supreme Court had said it didn't matter in Mobile versus Bolden that in 1980, it's when I became involved and met Armand, uh, that it did not matter if the effect of a law was discriminatory, that you had to also show that it had purpose, that the intent of it was. And some wag in the Birmingham paper, this is a Mobile, Alabama case, or maybe it was New York Times, I never remember, but he said, well, what are we going to do? Dig up those legislators? Dig up those stakeholders? Now, what did you mean when you were writing this? Did you mean to keep black people from being able to have a meaningful vote and to win elections or to elect candidates of their choice? And Armand and Lachlan McDonald, the Menifee, some other attorneys knew that this is what historians do. That is, we look at motivation and intent. And that's how we got involved. But Armand, along with John Lewis, also worked on Congress in the renewal of the Voting Rights Act, which was coming up at that time. It was renewed for 20 years and changed the law. Congress bipartisanly knew that this was not right and got the law changed so that it could be either effect or purpose. The other thing is purpose is very difficult to show. There had been guidelines. If we look at some of these cases about undermining, this is what breaks my heart. It was hard to do, but we did it. We did it in Texas, didn't we, Armand? Uh, uh, we done it, but now, just recently, they just took away that pretty much. The old Arlington
Should we,
Heights fact.
Vernon, is
Yeah.
it time for us to see if the audience people have something to say?
I think so, but I wondered if I sent the other slide, if somebody could put up those cases, if anyone had any questions. But I'm
So I
ready.
see another email from you, but I
Uh-huh.
don't see another slide on there. So I think
Oh,
the attachment didn't get sent, didn't get
uh,
actually uploaded.
let's
But
see.
We're
I
great
can,
lawyers and
while you're
historians, but
looking,
not much
It's
on the
it's,
technology.
it's in this one. Okay. All right. Yeah, I don't understand why I was able to share earlier and can't now. That's
you can try, you were sharing when you said you weren't. So you might try hitting that green button again if you wanted
I'm
to,
just
or you,
not seeing anything. Maybe that was it then. Yeah. Okay. Uh But I agree with Armand. If I just thought people might, since we were talking about some of the cases, is is this sharing now?
it's sharing your desktop. Yes,
And it's
Wow.
sharing the slideshow?
it is not sharing the slideshow. You might have to go,
Oh,
to PowerPoint icon down here at the bottom.
and that's disappeared. Maybe we better see if there's any questions and we'll play with
Yeah,
it.
sure.
Come
There
back.
are some questions. Uh, the first question you have is that Tom Hartman has said that the corporations are people decision was an error made by a court clerk. Are you aware of this argument and do you have an opinion on this?
I don't, yeah, there have been various theories, including one that it was a conspiracy by uh, uh, a few politicians. Um, I think by and large, most people think by and large that the decision was thought through and makes some sense, frankly. The problem is that um, you can take a principle and run it into the ground. So, for example, uh, it's easy to see, for example, let's suppose a corporation owns a piece of property. Well, you can't take my property, you can't take my house, you can't condemn it unless you pay um, uh, fair compensation, and it's got to be done through a certain procedure. Well, if my house was owned by a corporation, the theory, if corporations are not people, the theory could be, well, you can take their house because they're not a person. So I think the theory that it was done by artifice or inadvertence or whatever goes too far. Uh, but there's certainly the theory that has been used in years, in succeeding years, of giving corporations every right under the sun and more rights than people sometimes. Uh, that is something that bears some fruit. That really makes some sense.
And I disagree as a historian a little bit with Armand, which is not unusual. And thank
Yeah,
goodness my wife is not here because she always voted with him, or it might have been a we might have had a bestseller, Armand, if you two hadn't had voted me all the time. But you know, it was one of these Tammany Hall politicians that later on, when they were looking back at the founders, or rather the 14th Amendment adoption, did they mean it or not, who was saying, of course, we meant it about corporations. So I'm a lot more suspicious of what was going on than Armin is as a lawyer saying, well, there are good reasons that would be. And part of it is how it's been used immediately almost for these big corporations when railroads were coming along. And as much as I love Lincoln, he was a corporation railroad lawyer too. So
Yeah. Vernon, I saw you send another email, but again, that slide for some reason isn't showing up in the actual attachments. Um, so I wonder if it's still up. If you go down to your PowerPoint presentations at the bottom, that app, that's orange circle, is it still in there?
let's see.
At the bottom of your screen, there's a orange circle in the PowerPoint app.
In the PowerPoint app,
Yeah.
an orange circle. No, I don't see it.
At the very bottom of your screen.
On the slide itself with just the with just the screen, right? I could do, it was in the old one. We put that one in that I was going to show.
Right.
But I
So,
go back to that one. We could see what we could do.
right, that's what I'm thinking. And when you're sharing your screen right now, so I see your emails and things.
Well,
And if you just
there.
if you scroll like just move your mouse down
Okay.
and then to the right, do
Okay.
you see this orange circle here that's
Right there.
between,
Yes.
yeah.
Let me go back while you're wrestling with that. Let me go back to the
So
corporation
now,
question. Let me go back to the
Um,
corporation.
so if you, yeah, so maybe go up to window. Sorry, Armand.
Yeah.
go up
Uh,
uh,
if you go up to window,
to view
window
window.
is to the right of view on that same,
Yes. Okay.
yeah. And then if you go down, see where it says Detroit Library PowerPoint, if you click on that.
It's going to be a different one, but that's okay. All right. This one would be the
Or
one that would bring up
sure, you can try that.
that one if we wanted. Did that do it?
Not yet.
Okay.
But I can
Okay. I do
also
want to go
ask the
back to the
other
corporation
question
question.
here. There is another question if you have, unless you, this is,
It's neither one
if
of them.
you want to, Armand, say something,
Go ahead, Armin. Please.
Yeah, I want to go back to the corporation question.
go for it.
Okay. A good example of the way the basic principle, which is that corporations shouldn't be deprived of rights just because of the form that they're in. That's one thing. But what has happened is that corporations have been given more rights than people because they live forever. They don't get put in jail, things like that. But a good example is the Citizens United case, which held that corporations have all the rights that human beings do in campaign finance. And that really didn't start out that way. In 1976, for the first time, the Supreme Court said, well, campaign contributions can be a form of First Amendment expression, and therefore Congress can't just pass any kind of campaign finance regulation they want. There are some First Amendment limits on that. But in that same opinion, they they did not free corporations to engage in any kind of campaign finance. And several times after that, the Supreme Court kept saying uh, corporations don't have campaign finance rights that people have. And Chief Justice William Rehnquist, one of the most conservative justices, wrote that. Sandra Day O'Connor wrote that. Uh, corporations have been barred from making campaign contributions by the Tillman Act of 1907 that Vernon referred to. And then suddenly, in 2000, whatever it was, 2008, I guess, or 2010, here comes the Citizens United case and just overturned the whole thing. So the problem is not that corporations have some rights in some instances, but that corporations, especially in recent years, have been given all the rights in the world and overriding the rights of human beings.
Hmm. Thank you, Armand. We have another question. How can any legal argument be made that would support equal representation for every citizen when partisan gerrymandering has been considered legal by the Supreme Court?
Well, one thing, um, first of all, the Supreme Court said it wasn't condoning it. It said state courts can outlaw partisan gerrymandering. Congress, if it wanted to, could outlaw partisan gerrymandering. State legislatures and state constitutions can outlaw partisan gerrymandering. And most people really don't like partisan gerrymandering, which is why most legislators are not willing to admit they're doing it. They lie about what they're doing. But when the people get a chance to vote, they often reject partisan gerrymandering and either create commissions to do the reapportionment or do other things. One good example was in Ohio a couple of years ago. There was a ballot, a constitutional amendment about abortion because the legislature had put very strict limits on abortions. A big majority of the people were against those limits. So there was going to be a constitutional amendment. And as I recall, the rules in Ohio, the Constitution of Ohio at that time, this is no more than about 5, 6 years ago, said constitutional amendments are voted by a majority of the people. Well, suddenly the legislature introduced a proposed constitutional amendment that would amend the constitutional number rule and say you can't have a constitutional amendment unless it's approved by 60% of the people. And so that vote took place before the abortion amendment vote, and it went down to very significant defeat. And it went down largely because even people who were in favor of abortion restrictions and were against the abortion constitutional amendment didn't like the idea that the legislature was messing around with the Constitution. So what we really need is enough citizen support, and the League of Women Voters is a powerful voice there to make these legislators ashamed and unwilling to say what they are doing and punish them if they engage in radical partisan gerrymandering. I mean, partisan gerrymandering is crooked. That's all it is. It's crooked. And people who do it ought to be punished by being kicked out of the legislature. League of Women Voters, it's your job.
A follow-up to that, what would or what could be a good legal challenge using the Constitution to the partisan gerrymandering issue?
It would have to be in state court, I think, because the Supreme Court has said it's just not going to get into partisan gerrymandering. The one issue that could make a difference is if something is a racial gerrymander, and frankly, most partisan gerrymandering does, or a lot of it, where there are people of different races, a lot of it is racial. And the reason is sort of, for better or for worse, and whether you think it's a good idea or a bad idea, oftentimes politicians and other people tend to think that if they want to gerrymander, the easiest way is to move racial voters around. And so if the Supreme Court would honestly view racial gerrymandering cases, that could limit what amounts to partisan gerrymandering. But as I said before, I think the Supreme Court, for some reason, loves partisan gerrymandering more than it says it dislikes racial gerrymandering.
I have a question a little bit about, and maybe you said something more clearly, and I just didn't catch it all because it was on other things. But you had said that there was oh shoot, I had my question and I lost it. Sorry. Oh yeah, so that the sort of undoing of Reconstruction is similar to what's happening right now, in that they're sort of overturning cases, over saying that Congress doesn't have that authority, or that someone else does have that authority. Was there a way, like, and I guess that was the first time also that I had heard that states were sort of, before the Civil War, states were considered to be the sort of more powerful group, and that after, during the Reconstruction process, it sounded like you were saying that the federal government was sort of becoming more powerful. And I wondered a few things about that. Is there is that where there's still folks who argue for states' rights, or like sort of more like local, is that the seed from where that comes from? Is sort of the first quick question, I hope. And then the other is just how how did some of that reconstruct? Obviously, we had the civil rights movement, we had folks engaged. What were some of their strategies? Are there any of those strategies that are applicable today that could help us ensure that everyone has equal access to voting?
I really think that is a great question, and there's several parts of it. I know Armand will want to speak to it too, but let me just take the last part that I think that one of the things we tried to do that was unique in our book. There was this division between Thurgood Marshall and what he saw King and SCLC, the NACP. He went along with. They were doing the legal cases, but the marchings and the I think it was a combination that really made the difference. That the protest, the sit-ins, the bus rides, King's idea of an unjust law and suffering the consequences. The kid right here in Rock Hill, South Carolina, that said, no bail, go to jail instead of just getting bail right out. All of these things, those protests, uh, along with the law, made a difference. I think people have to stand up. Uh, I think there's nothing like public opinion. And we came to rely, I think, on the law. My generation grew up with the Warren Court. We grew up with the court that grew out of what we have argued Charles Evan Hughes really began. A court that, whether you agreed or not, they had their reasons, they laid them out, they had some evidence, some basis, they made the rational arguments, and we pretty much accepted them. And I think that what we call the second Reconstruction is the civil rights movement. And there was a great quote by Diane Nash's husband at the time that there is no more civil rights movement. Lyndon Johnson, signed into law with the Voting Rights Act of 1965. My argument is, in fact, the civil rights movement continued with attorneys like Armand Derfner and others, and Frank Parker. It was just in the courts, and we relied on the courts, and they worked until we thought the courts would always be that. It's like democracy. I truly believe that we don't understand that democracy is not static. It goes forward sometimes and it goes back. That's why I talked about sort of these lessons of history. Ever how you look at it, we can learn. And the way the textbook teaches it, Reconstruction just ended all of a sudden with what was called the Wormsley Compromise. There's been a lot written about the compromise election of 18, but it did not. You had blacks in Congress, you had in the state legislators, uh, and our state of South Carolina, one of the most interesting cases, African Americans were still protesting, and it went to the court. They won in the federal court that the 1895, 1896 Constitution was not, South Carolina was not constitutional. But when it went to the Supreme Court, they had, well, yes, and you know how long it takes for these cases to get to the Supreme Court. I've been working on some things I'm going to talk about in Florida next week. When people are in jail 10 years before their case gets to the court, and then they're overturned, they can maybe be released. But by the time this got there, they'd already held the election, and so the Supreme Court sort of said, well, yes, it probably is unconstitutional, but since you already held an election on it, we're going to let it stand. So I think that it's like that when Justice Roberts ruled against basically Section 4, which just gutted the Civil Rights or the Voting Rights Act, was Section 5, which was the main way uh, that uh, unjust or unfair laws had been stopped in those states and those jurisdictions which had most done them. Those, that is the covered jurisdiction. He said, well, you still got, you see, Section 2, so it's no big deal. But then Alito immediately started going after Section 2 as well, and that's where we are right now. I would say it's hanging on by a thread, Armand. That's why one of those other court cases. I tried to send the slide again. I don't know if that one got through or not.
No, I had another blank.
Oh, I can't understand it. It's there when I show it. Okay. I'm not hearing you. Think
I'm not, no one's talking right now.
Sorry, I was on mute. Uh, so I don't have any other questions in the chat. I don't know if there's any time still to let any questions, if there's someone in the audience to unmute, Jennifer.
We can. Does someone have a question that you'd like to ask?
Or comment?
Yes.
You can
or a comment.
You can use the reactions at the bottom
Yes, you can
of the
react
screen
and
to
raise your hand. Cheryl, I meant in Zoom, raise your hand, but you can unmute. Cheryl, you can.
Yeah,
Yes.
okay. And I'm asking this just because I was discussing this today. So I actually put it in the chat, but I didn't incorporate it in. There is so much you seem to really blame the courts, and I certainly the Supreme Court. I have too. I felt like they have reneged on what they're doing, what little I know about the law and the Constitution. But the person I have discussed this with recently really thinks it's the legislature that is not holding up. The Congress is not doing what they need to do. But it seems to me if the court makes a decision on things, and maybe they've only made these decisions because Congress hasn't done their job, but um, is there anything that the Congress can do if they dislike a decision or an outcome through the Supreme Court? Is there anything anyone can do? We can any lawyer appeal what the Supreme Court does?
Well, that's a big question. But in
I'm sorry.
general,
No, it's a good question. It's
Yes,
very
let me
Congress
know
has
if you want to talk about that later in
Congress has
another month.
okay. Well, Congress has the power of the purse. Congress has the power to confirm or not confirm appointments. Uh, Congress could have given us a different Secretary of Health and Human Services.
Oh,
Congress can or choose not to fund ICE. Congress can, there's just lots of things Congress can do. But you're right, we've had a process for many years in which the executive branch, for a variety of reasons, has taken more power in all administrations. Think how many wars we have had in the last bunch of years. We've had many wars. When is the last time that Congress declared war, which is what the Constitution says? The answer is World War II. We've had endless wars since that time, but there's been no declaration since 1941. Well, Congress can do something about it with the power of the purse, power of confirmation, and frankly, telling the executive, this is something you may not do. Congress seems to be acting up a little bit when it comes to Jeffrey Epstein. To a certain extent, part of the problem is what do the people back home say? What do the constituents say? So there are no easy answers, but there are things that are worth that some actors in our government can do.
And can I add, Armand, that
Please.
when in Mobile versus Bolden, the Supreme Court said that you had to show the intent or the purpose, and we have a whole chapter dealing with how that's changed over time and things. But you, with John Lewis and others, went to work on amending the Voting Rights Act and amended it so that it was accepted. So there are ways that the legislature can do things. Now, that could have maybe been challenged, but it was not. And it's taken a long time for them to come after it. to stop
The
work for a long time.
president is really intent on affecting the election, the congressional elections of this year. Obviously, the president realizes that what he can do or not do will depend very heavily on who's in control of Congress come next January.
Right.
Well, I
Well,
think we
thank
should
you.
probably try to find someone who can speak on what the individual voter can do to try to encourage these changes that many of us agree need to be made. Does anyone else have any questions that you'd like to ask?
Well, on that list, which I'll try to send one more time at a new one, we have the Freedom to Vote John R. Lewis Act.
Yes.
That is one way to handle this, I think. Now, no one's saying it would not be challenged, but I think that would be one way that we.
And that has not passed yet, correct?
No, it is not. I think most people thought it would be an easy thing to do.
It sure sounded
Most
easy.
people knew it would not be an easy thing and it would never pass.
It just, again, we have only been this partisan and probably not as divided with just the two parties since the Civil War, and you saw where that led. This is why I started about lack of discourse and how important that is, and why I think something like, the League of Women Voters is so important, to be a nonpartisan group that tries to get people to understand and think about issues. It's just we're not doing it, and we are getting more and more and more into silos. So, I think it's critical that we try to get people to understand how important of what's going on that we've been dealing with.
We have not so much a question as a comment from Deborah asking for some hope. Where do you see hope? Where do you see lines of action that give you some hope in this?
Well,
I see
it.
Hope.
Yeah, go ahead, Armand.
I'll just say one quick. I see some hope in the debate over immigration, not necessarily in the battles in Minneapolis or whatever, but I think we have a huge issue there. That is, there are probably 10 million people who are not documented who live in this country, and a lot of people who may have thought, let's just get rid of them, are now seeing that they themselves are not necessarily in favor of some kind of sweeping solution like that, even if it could happen, which it can't. And so I think people on all sides, that is, people who theoretically want to get rid of 10 million people, and people who want everybody to stay, I think everybody is seeing that it's not a simple solution, and that may be an example of where people can start to think we need a real solution, not just battling it out.
I see it in two areas besides what Armand is saying. I said one is I think people have to make their voices known. I have been impressed with these protests that have gone on. A number of people there. That's one way to let people know they're not alone and just frustrated and trying to do something. But particularly, I have argued, and this goes back to where I cut out what I was going to do at the first. Lincoln, in the first time he ran for office, and really the only time where the people had direct vote that he really, really lost, where it wasn't like the legislature electing people. And he said to the people, when in Sangamon County and the little community he was in, that the most important issue was education. And obviously I'm biased. The academy is no saint right now. It's horrible things are happening. I resigned from Clemson because they're firing of three people without due process, without faculty involvement. And it's not just Clemson. It's throughout the nation. People are terrified of funding and the bullying mob tactics of this administration. I'm sorry, I know we're supposed to be nonpartisan, but if it was Democrats doing it, I would say the same thing. Uh, and what I truly believe is part of this reaction has come about because of the great job that school teachers, all school teachers, but particularly public school teachers have done. This myth that was created about Reconstruction and taught so many years. Now, we knew better than that when I went off to graduate school right out of the Army in 1969 at Princeton. But it took a long time for that to get down to the education schools, and then from that into the public schools and these school teachers have been doing God's work. They have really done it. I am shocked. The most conservative, and I don't care if someone's conservative or or right wing even, or as long as they are willing to use evidence and make their argument. I want to understand they believe these things. I have yet to meet a student who wants to be prejudiced. So part of it is not understanding how laws work. I worked at the National Center for Supercomputing Applications. I work with scientists. I love scientists. I support STEM. But history, what we used to call civics, are important too. Um, and if we don't understand that, if we don't understand how our government works, then we're sort of subject to the kind of things that's happened to us now. And I think one of the reasons that legislatures in Florida, Texas, South Carolina now, most particularly in southern states, but not exclusively, are saying you cannot teach about certain issues. Basically, anything that make someone feel bad, like enslavement or lynching or those sort of things, is because of how successful those public school teachers have been with young people. And they are coming of age
Amen. Amen.
citizens. And if they can understand, because they haven't been taught, you're no longer required to sort of understand how the government works. The people who understand best how the government work are the people who are coming in and getting their citizenship as adults because they have to take tests that most students couldn't pass. And I mean this as a real crisis. It goes back. I love what Lincoln generation called. I've taught at land grant schools deliberately. I've had my chance to go to Ivy Leagues. I love land grant schools. And when they came about, people were calling them all sorts of things, farmers' colleges, people's colleges. What I loved was the term democracy's colleges, is what they were called. And I think we need to reclaim that mantle of all education is democracy's colleges. Uh, that people, and that's partly why Armand and I wrote this book, that Armand actually asked me to join him in doing this book, was to try to educate people about how the law, and particularly the Supreme Court, works. This is beyond our scope here, but in the process of this, you wonder how race came about, since there's no such thing as race. There's no genome. There's nothing, I mean, nothing that says that an African or somebody like me from Georgia or a Lutheran or a Presbyterian or American has a different gene. It's just not true. Or my mother used to use Lincoln's phrase, ancient faith. And my mother taught me that all people are created in the image. However you want to look at it. So how did it come about? That's one of the things, Armand, the laws made a distinction on race. And Armand worked out this thing of every 25 years, of a generation. And when those first laws began in the about 40s, Armand, we figured where we started. There had been 12 generations of laws that not only disadvantaged a group, discriminate, but even laws that said a white person couldn't be involved with those people or do things either. It affected white people as well. And as he said, we've only really had two generations to undo those things. So it helps us understand how far we've come in the long perspective of history. And things do change, but people have got to be aware and they've got to be committed to democracy. There's just certain things like accepting elections that have to be part of a democratic process. People voting, that those votes have to be allowed to be counted. So, I worry because we haven't even got it into the social media and how the First Amendment even going to work in this kind of crazy environment. We're seeing the fourth estate just disappear before us. It used to do investigative journalism. So, I think
Yeah.
people have to stand up.
Yeah, I think we're getting close to the time where we have to close out here. Thank you so much for
Yes,
all of
thank
your
you.
thoughts, and it was
Thank you
very helpful to give
both.
us a little bit of hope. Thank you.
Yes.
Nobody knows the law better than Armand Derfner.
Well,
Now,
I think what
eh,
Vernon just said is a really eloquent way to
Mhm.
end.
Yes, and we'll talk about another program because you raise lots of topics that we would like to get into. Uh, I am starting to think that maybe this isn't being recorded. I'd recorded it,
I hit a
but
button that said it was being recorded.
Yeah,
you got a message saying it
I
was?
did too.
I
Good,
hit
very
it.
good.
Yes,
And it
yes.
says the recording up here.
Okay, I
Yeah.
don't see it. And I was seeing a notice that it was being transcribed, so I was worried. This is where this recording will be posted. Usually it's faster than it used to be, so maybe in about a week. And after that, it will be on the League of Women Voters Detroit site. And if you need anything, any other information, if you have suggestions about programs, you can email me, and we are happy to have suggestions. We are happy to have people here. We've really enjoyed the presentations from Dr. Burton and Mr. Derfner. Sorry, I'm blanking on what to say. But thank you very much for attending, and thank you. I'd like to talk with you about another topic. We're looking for later in the year, so we might have you come back to talk about civics and the importance of civics. Thank you, everyone.
Yeah.
And
Thank
you to the committee, to Ruth and to Cheryl, and to Deborah, who
It would
did the
be
introduction.
good if this is not recorded. And my old friends at University of Illinois, where I helped develop this world of, where Mosaic came out,
Mhm.
all of that. It was one of my students. If they did not know that I don't even know how to share a screen anymore, I'm a Luddite.
Yes, I can understand
It's
being.
like civics with other people. I'm complaining they don't know their civics. So I went from being very good with computers to I don't understand what's happening anymore.
Mhm.
What crazy world have we created?
Yeah.
Yes, I'm going to stop the recording now and we can chat a little bit more.